All right, we got a letter in the mail from a patent troll. Patent troll, baby. They want to take you down for a patent when they know they're losing the argument and they know it's a false claim. So if you know about patents, you can protect yourself and also make sure that when you file your own patent, your own intellectual property, that it is valid, that it is actually defendable, and you will win in court if you go to court. The worst thing you want to do is mess up these little tiny mess ups. This company did mess up that's writing to me, and therefore their patent is not valid. Now I'm going to talk about some legal definitions, okay? And first one is patent. What is a patent? A patent is a legal right for you to be the only person to sell an invention. Okay, there are two main types of patents. One is called a utility patent, which means something that you created that does something special, okay? You're the first person to ever create a milk frother, okay? You created that whole gadget, the thing, it's never been invented. It's a brand new thing. 2-in-1 lemon squeezer. You're the first person to do the 2-in-1 lemon squeezer. These are in MySpace. These two are utility patents, okay? Now, the milk frother one was not filed in time, and therefore that does not exist, okay? The 2-in-1 lemon squeezer was filed right on time, okay? You have 1 year from what's called public use or sale. So as soon as you put your invention out into the market, you send that on email blast, you put it on Kickstarter, you send it to some sort of publicly available place, and you send it. For the utility patent, that's what that is. For design patent, okay, that is you made something look in a certain way. So this boom arm, whatever camera thing that I have here, somebody first invented this arm. But if you create a special way, like a special circle, a special square, or some little design, something that makes it look different, but you actually didn't invent this type of arm, then you can get what's called the design patent. And by the way, this is my understanding of these words. I am not a lawyer. This is not legal advice. I'm telling you my understanding. So moving forward, for any patent to be valid, the USPTO, the United States Patent and Trademark Office, okay, that deals with all intellectual property in the United States, they have certain rules. One of the most important rules is they're on their website. So you can go to the website. The website is pretty long. I'm going to read it, and it's going to have it here on the screen. Okay, uspto.gov/basics/patent-process-overview. It's a long website, but on this website, directly from the government, this is what they say. On section C, first one is to basically say what type of intellectual property you need, whether that's a patent, a copyright, a trademark, right? Those are the three things that they cover. Okay, the second one is determine if your invention is patentable. Okay, if you say I invented a pencil, or I invented it to look a certain way, it may not be patentable. Okay, C, search to see if your invention has already been publicly disclosed by another party. You cannot get a patent if your invention has already been publicly disclosed. Therefore, a search of all previous public disclosures should be conducted, including a search of foreign patents and printed publications. Now check this one out. A public disclosure of the invention made by or that originated from the inventor or a joint inventor more than 1 year prior to filing a patent application for the invention will also preclude patenting. Preclude means stop it, make it impossible, make it not happen. What does that mean, all this legal stuff? My understanding, if you don't patent anything that you actually invented within 1 year of anybody finding out about it or you disclosing it, if you put it in a catalog, if you put it in a magazine, if you put it in a blog article, if you put it in an email, any sort of sending of that information for sale or for viewing to the public starts a time clock, and you have 1 year to file your patent. Now, there are many cases where someone files it after a year. And if you go to court, the law says right here, the USPTO tells you you have 1 year to file it. So if you file it in 16 months after releasing it to the public, the USPTO will grant you your patent. They'll give it to you. Why? Because the USPTO does not have that many staff, and they get tons of requests all the time. They do not have time to review every single item and see that it wasn't for sale 12 months before filing. So they will not stop your thing. A lot of people still file patents, even knowingly. I know a person, and this, I'm going to say it publicly because it's really frustrating. There's the manual burr grinder, and there was this guy who went on stage, the Java Press, okay, was the brand. And he went on stage and he said, I tried to file for a patent, we couldn't patent it. And then a year and a half later, something like this, he said, and this clip was cut and it's no longer available, but I was there in person when it happened. And he said, my lawyer told me a way to get around it, and we patented this thing, and in fact, they took down our manual grinder. But they filed for the patent a year and a half, 2 years after they already were selling it. Now, could I go and fight this in court?
Say yes.
Yes, I could. Okay, it's not a big item for us. If this was a big item, we would have sold it well. We would have gone to court. My almost certainty we would have won because there is proof and evidence that I have that this item was already for sale in the exact format more than a year before. And in fact, they actually unpublished their video on YouTube that was showing the inside of it. And I have that all recorded. I might even make a video on that. But they're hiding that because they used Amazon, because Amazon, again, like the US Patent and Trademark Office, they're not going to look and see if this patent is valid. They're going to look at the USPTO and say, oh, that's valid. The USPTO says it's valid. We believe it's valid. We'll shut down your listing. Okay, that's generally how Amazon works. They look at the USPTO, but the USPTO doesn't review the 12 months of information if that thing was for sale 12 months before, like the law does. The point is, where this matters is if you're going to take it to court, this is how you defend yourself. And if you actually invented something, you need to make sure you file that patent within 12 months of showing it to anybody in the public, because otherwise your patent is unenforceable and invalid. And I'll give you, this is some information because there's more than one way to invalidate a patent. This is a website called upcounsel.com, and they're saying how to invalidate a patent. So the idea is there's basically two ways to invalidate a patent. One, say there was prior art, someone else did some invention that was very similar, and you could say they invented it before you did. If someone else did it, then you're not actually the inventor. You can invalidate a patent that way. And then it says here, providing proof of sale or public use. Another way to invalidate a patent entails providing proof that the invention was on sale or in public use in the US within the past 1 year period before the date of patent application filing by the applicant. If it is proven that the invention was described in a publication, patented in a foreign country, or known by inventors in the US before the applicant invented the invention, the patent becomes invalid. So those are the ways to invalidate a patent. Now, if you're in litigation for a patent, you can get advice from a lawyer. I am not a lawyer. I'm just telling you my understanding of things. You can either invalidate a patent. So let's say you find out someone's telling you you're infringing on something. You either are infringing, which means you are using their invention without permission.
That's mine. So?
Or the way, if your product basically is infringing, then there's ways that it actually isn't. Okay, sounds a little funny, but if there was prior art, meaning, and I know this to be the case in several cases, someone files for a patent 4 years after it was invented, that patent is no longer valid. So you're not actually infringing on the patent because the patent is invalid. So either invalidate the patent by saying the inventor released it, or by saying someone else released it before that time period. Or you could say it's unpatentable. Like, you can go into the specifics of the USPTO, and there's some correspondence. I believe that's publicly available. And if there's something that they did not know, they did not have information, that information would make it invalid, then you could also then win a case in terms of infringing. So that's my summary of patents. Patents are very important. If you're going to spend the time to design something, you're going to make a mold for a product, you're going to design it, you put an invention. We have filed patents ourselves. So we've created something. We hire a designer. Now that I've actually co-invented a product, maybe one, maybe two. So there's an original inventor, an idea, some design. I'm now working with that inventor to make it a specific thing. There will be co-inventors. Now we both invent it. That gets assigned to our company because we pay them for that. Now I have to file that within 12 months and get approved by the USPTO for that patent to be valid. Don't be the company that waits more than 12 months and then files it because it's unhonest, dishonest. It's a wrong thing to do. And if you go to court, you're going to lose. And now, again, there will be people, and I've seen it, as this Java Press example. They publish it, they file 2 years later. Now they're going to try to hide those original findings. Guys, that's an illegal act in some way or another. I don't exactly know the fine, if that's perjury, what that is. If you go to court and say, no, we didn't have that, this is a valid patent. I don't know what it is, but it's wrong. Don't do that. Don't be like that, okay? That's all I have to say. Patents are important. You should be inventing stuff. Inventing stuff is cool. It's fun. It's awesome. Design patents are easy to be created. Back in the day, utility patents were like the gold standard because it's easy to like sue people with it because you actually created something brand new. But design patents are very valuable in the Amazon world because if you have a design patent on Amazon and you show it to Amazon, it's a valid patent. It's the process of getting that other product shut down is pretty easy. So if you invent stuff, do it. But no, if you see someone filing for a patent and that thing has been in sale for more than a year and you have evidence of that, you can challenge that to Amazon. You can challenge that in the courts and you can fight for your right for it because nobody should be above the law. When I started Amazon, I had no idea the crazy legal battles that I would go through. I knew nothing when starting. Now that I've researched and know about patents, about trademarks, about copyright, I want to share with you a little bit about patents, the most important.